Welcome back to TuckerAllen Live, right here on Facebook. I'm Scott Trout, the moderator, and today I get the pleasure of doing this outside while Kevin, our TuckerAllen attorney, is inside. Welcome, Kevin.
Hi, Scott. Thank you so much for having me today.
Well, today we're going to talk about what I'll say is a dirty word, and that is probate. And no one wants to be part of probate, and that's what we've been talking about for over a year. And, you know, it's a big word, it's a dirty word. Let's maybe start right there. Tell everyone right here on Facebook, kind of what is probate, explain the process. We'll go through, you know, some of it, but more particularly why it's not something you really ever want to go through.
Sure. So what probate is it's kind of the process of going to the court, and you go to probate court is what it would be called. And it's the process of kind of distributing assets after someone has passed away. And you go to probate if you have a will, or if the person who passed away had a will, or if they passed away intestate. And passing away intestate means that they had no will, they had no estate plan, there was nothing there. So whenever you don't, or if you have a will or don't have an estate plan in place, then you will have to go to probate court. And kind of the reason, like you had mentioned, it's kind of like this dirty word, this big word, is that probate can be a very time consuming and kind of, you know, it's an expensive process here in Missouri. It's kind of set up on a schedule based on the number of assets the person who passed away had, but you can kind of expect anywhere from 4 to 8% of your total estate, plus the time of going to court and having to deal with, you know, a lawyer and a judge.
Yeah, I mean, who wants to give up more money, you know, especially to lawyers, right, in a stressful time when you've lost a loved one, a friend, you know, a relative, whatever it is, a spouse, you know, a son, a daughter, a mother. And now you've got to go to a lawyer who's going to say, well, I've got to charge you because these fees are set by statute, right? In Missouri, at least, it's a percentage of the estate value.
Yes, it is. So it's set statutorily. That's just kind of, it's a statute. That's the way it is. There's no getting around it. And like you said, you want your family members and your loved ones to kind of be able to grieve and not have to be dealing with the court and dealing with probate judges and attorneys and things like that, plus the expense. So there's kind of there's a lot of negatives, I think, to probate. But yeah, you kind of would like to be able to give your loved ones a chance to grieve and not have to think about being the executor and what all goes into that.
Yeah, I mean, I always try to think of an example, and sometimes my examples are way out there. But for me, it's like a seat. You know, if I'm going to get in an accident, I don't want to be ejected from the car. And the point is, it's as simple as putting my seatbelt on. And the things that I want to talk about today on how to avoid probate are your seatbelt. And they're just as simple of, you know, reaching over, putting that, and then hearing that click. And so let's talk about it. Trusts and pour-over wills. Those are the seatbelt to avoid probate and the accident and the crazy, you know, attorney's fees. So maybe talk a little bit about how the trust and the pour-over will can assist them to avoid probate.
Sure. So a trust is a document that allows you to avoid probate. So it's a completely probate avoidant document for any asset that is funded into the trust. And so whenever I was in law school, this may kind of be a goofy way to kind of think about things, but a great way to think about a trust is as if it's a bucket. My job as the attorney is to create this bucket for you that then you take your assets, you pick them up and you place them into the bucket. And while the person who is granting, the grantor of the trust, while they're still alive, they carry this bucket around with all of their assets in it. And so whenever you pass away and you have a trust, this trust, you know, bucket holding all of your assets, then you can have a successor trustee that steps up and then they can reach into the bucket and just pass out your assets to you or to your beneficiaries without having to involve the court at all. So it's a completely probate avoidant tool for any assets that are funded into the trust.
I mean, it's been the whole point of these, you know, Facebook Live or virtual town halls, and that is taking steps. There are steps you can take to avoid the one thing that this dirty word probate, and they're less stressful. Honestly, if you're watching, they're less stressful than having to go through probate and the time of doing it. And I think it's so key. And it's simple of go get a will. If you don't want to do a trust, go get a will. I get it. And then we recommend doing a trust to ensure that everything passes over and out of probate. So we've also talked about TOD and POD. So maybe talk a little bit about those are, because a lot of people do use those two things.
Sure. So those are kind of a great tool. If maybe if my clients didn't have a lot of assets, or if they didn't have children, or really, it just kind of depends on the situation. But there are times where a will plus these transfer on death and payable on death designations can be really useful. So, and I use the transfer on death and the payable on death designations in conjunction with trusts as well. So what that means is these designations are saying that we have kind of like a list of potential beneficiaries for an asset, and you have your contingent, you have your primary beneficiary, then a contingent beneficiary, and it's TOD. And what that means is it's transfer on death, or it's POD, payable on death, depending on the type of asset it is. And what happens is at the death of the person who owned the asset, you'll probably have to prevent like a death certificate, something like that. And then what happens is it is immediately transferred to that beneficiary. So like the way that I would use it with the trust is, maybe it's a little bit more difficult once you already have your bank account set up. You don't want to go open up a new bank account. That's fine. We just make your bank account payable upon death to the trust. So now it's running through the trust, and it's kind of the same. We have beneficiary deeds here in Missouri that we get to utilize, and that's the same idea where we can make your beneficiary deed. You can do it to an individual or an institution, and with a trust, I just make it, transfer on death to the trust.
So as I think, kind of coming back to the will part and the trust and the core and the seatbelt idea, I put the lap belts on, but not the shoulder belts. I mean, you don't want to have a false sense of security that a will do it for you. Without a trust, the will, does it have to be probated without a trust?
Yes, so a will without a trust, a will would have to go to probate. And just to kind of touch on what the pour over will is, I know we've mentioned it a couple times. A pour over will is used in conjunction with the trust, and it's like the seatbelt maybe for your trust would be a good way to think about it, because what it does is, like, I've created this bucket for you. Hopefully all of your assets are in the bucket, but then what happens is, you buy a vehicle, you forget to use that transfer on death designation for your vehicle to your trust. So now the trust would have to go through probate. And what this pour over will does is, the way, again, kind of the goofy way to be taught this, but it really helped me remember, is the pour over will is like a pitcher. It reaches down and scoops up the assets that didn't get put into the bucket, and then it pours them right into the bucket.
So I think, perhaps all of us get lulled into a sense of security if we take property in joint ownership. Is that a problem? You get married, or you have a partner, and you buy a piece of property, and you take it by joint tenants, either in common or by the entireties, depending upon your state. Is that still a problem for probate?
So it kind of depends. I'm hesitant to get like too far into the joint ownership, because there are so many technicalities, like you're saying, depending on state by state. Here in Missouri, we do get to utilize, joint tenants by the entirety. So that's, that can be a good tool to use. Also, like with, bank accounts, sometimes people will own bank accounts jointly with their spouses. So upon the death of one of the spouse, the other spouse is now they own the entire bank account by themselves solely. So that's one way to kind of avoid probate, because the ownership just passes to your joint owner. But I hesitate to get like too deep into it, just because there are so many intricacies with real property. But for like bank accounts, that's one way to avoid probate. The only thing that you have to think about with that is, we plan for every scenario. And one thing that I would be nervous about is like, what about like the car wreck scenario where both people pass away? So that's kind of where I get nervous with joint ownership sometimes.
Yeah. So as you mentioned earlier, the utilization of the TOD and the POD, it's something you utilize both with a trust and a will. Mm-hmm. It could be bank accounts, investment accounts, whatever it may be. So it's not just a otherwise, don't do this, don't do that. You can use them both together, correct?
Yes, absolutely. I would say that whenever I am drafting an estate plan for somebody, I'm probably going to utilize all three of these different options just in different ways. And it always just kind of depends on the client and what they're comfortable with, and kind of what their wishes are and their needs are based off of the assets that they own.
Awesome. Well, Kevin, thanks for simplifying it, explaining the dirty word of probate. No one wants to do it. We don't want to do it. We'd rather create strategies for you to avoid it. So thanks for joining
Yes.
today on Facebook and TuckerAllen.
Thank you so much, Scott. I appreciate it.
We'll continue to tune in on Fridays. Remember, it's the same time, 1 o'clock Central Time right here. We do TuckerAllen Live, just a short little bit of information for you to spur perhaps a conversation with an attorney that practices exclusively in estate planning and elder law, just like the attorneys do at TuckerAllen. You can go to their website at TuckerAllen.com and find out more information about them. There's all kinds of resources, there's podcasts, and also you want to make sure you look for the virtual town hall that we have every month where you can log in and ask questions live and get answers from the attorneys over at TuckerAllen. And if you need a consultation, you can do that right then and right there on the website too. They have offices in the Kansas City metropolitan area and the St. Louis metropolitan area as well, including a crossover into Illinois. So go find them on TuckerAllen.com and also follow them on social media right here on Facebook. We'll see you next Friday at TuckerAllen Live. Until then, have a great weekend and we'll see you next Friday.